NACDL is the association of the nation's criminal defense bar.
I want to talk about Batson versus Kentucky. When the Supreme Court decided Batson versus Kentucky, it said this is part of our unceasing efforts to end race discrimination in criminal cases. That was, of course, a complete lie. Nothing could be further from the truth. In fact, the litigation of Batson cases since then has mostly been efforts to avoid doing anything about the racial discrimination that takes place in criminal cases. I want to do a quick informal poll. I want to know how many people sitting there trying cases are trying cases pretty much always to all white juries. And how many people are litigating Batson challenges, challenging the prosecutor for striking people of color? Raise your hands real high so I can see them. And are any of you ever prevailing on those challenges? Well, that's very encouraging. Carlos, congratulations. I'm glad to see that. And how many, finally, are having Batson challenges against your use of peremptory strikes? Well, and that more and more, we probably are going to see that. Well, as everybody probably knows, this summer we had a Batson case that came out well. I read something the other day about how the Supreme Court has really gotten serious now about jury selection and decided another Batson case. But in fact, what they've done is only decided cases that were so incredibly egregious that there are very few cases that compare. Those of you who know the Curtis Flowers case out of Mississippi know that it was a case that went to trial 6 times. And every time the prosecutor used every peremptory strike he had against every African American that he had an opportunity to strike. In one trial, the third trial, he used 15 strikes against 15 African Americans. Even the Mississippi Supreme Court said that was a Batson violation, although it was a 5-4 decision and 4 of the justices would have upheld that. The last time, once again, he tried to strike all the African Americans, only left one on. The Supreme Court reversed, but in doing so, it looked back at all of those cases and what had happened over the course of 6 cases, 42 opportunities to strike, 42 strikes against African American, very disparate questioning of how the black prospective jurors were questioned compared to how the white prospective jurors. Extraordinary record that's not going to happen in the garden variety case that goes up. The same thing true of the last case I had up there, Foster versus Chapman, which was a case where we discovered the prosecution's file, which once you had that information, then you pretty much had a winning Batson issue, but how often is that going to happen? I want to make 3 or 4 points right at the outset and then talk a little bit more about them. First thing, for those of you who aren't raising the issue, I want to urge everybody to raise Batson issues, because if you are in a jurisdiction where the prosecutor is striking, and I'm going to, for the purposes of this talk, I'm going to talk about prosecutors striking and defense challenging the strikes. I realize it goes both ways. The prosecution will challenge you, and it happens in civil cases, but just to keep it simple, let's talk about what I think we normally are dealing with, which are prosecutors who are trying to get all white juries and who are striking African Americans, and defense lawyers making the challenge, and then how those are litigated. The second what I want to say about the first point is, even with judges who are denying these all the time, and even with prosecutors who are furious every time they're accused of a Batson violation, it is a question of accountability. And the more this is raised and the more it just becomes something we have to deal with, the better off I think ultimately we are going to be. The second thing I want to urge is to document what the prosecutors in your jurisdiction are doing. One of the things in the Flowers case was the American Public Media, which did a marvelous podcast about the Flowers case called In the Dark, Season 2. And they follow the Flowers case through all 6 trials, through the use of an informant, against Flowers at the trials, the jury strikes. And one of the things that American public media did was they went out and looked at all the trials that Doug Evans, the district attorney in that case, had tried, 225 trials. One thing about not having many trials anymore, there are not that many trials to look at. That was between 1992 and 2017. And he struck 50% of the eligible black jurors and only 11% of the eligible white prospective jurors. And every single study that's been done in Philadelphia, in North Carolina, all over the country, every study that's done has shown these kind of stark racial disparities. This wasn't a part of the record in the Flowers case. When it went before the Supreme Court, because this was developed by the media outside of the case, but obviously it could have been developed by Flowers' lawyers. And so that's important for us to try to pull that evidence together. It'll be harder and harder for prosecutors to strike all the African Americans if the statistics continue to pile up the way that they have in North Carolina and other places where those studies have been done. David Baldus did a study that's cited in the materials, and many of the things that I talk about here, the citations are in the materials. I hope you'll look at them because they're in much greater depth than what I'm going to be able to present here this morning. Third thing is the standard that was established in these cases was the strike motivated in substantial part by discriminatory intent. That's incredibly important given the way many courts are deciding these cases, including, and I'll come back to, the so-called mixed motives, where the prosecutor has one motive that's clearly a racial motive, but then some other motive that's not, and there are a number of courts that have said that's acceptable. That's not acceptable. And Foster says that, and Snyder versus Louisiana says that, and Flowers weighs in one more time with that. So if there are mixed motives, but one of the motives is race, then that strike should not be allowed, and there should be a Batson violation found. The other critical point I'd make is the totality. This is to be based on the totality of the circumstances. It's not one juror at a time. I see Batson transcripts where there's objections. The prosecutor gives the reason, juror number 1, judge says, okay, that's race neutral. Juror number 5 gives the reasons, that's okay, that's race neutral. That's not the way it's supposed to be done. It's supposed to be done at the end of all the strikes, at the end of all the arguments, and you look at everything, not just the strikes and whether there's a reason for striking juror number 1, but how did the prosecutor question the jurors? Were the black jurors questioned differently than the white jurors? Are there comparisons of jurors who were struck that are African American and jurors who were accepted who were white? That's critical. And it's interesting that in these cases that have been decided, the courts have often looked at comparisons that were not made at trial. That was true in the Snyder case, and Snyder's a good example of a comparison. The juror that was the center of the Batson challenge there was a young student named Jeffrey Brooks. And Mr. Brooks said that he was a student teacher and he was in teaching classes and being supervised and so forth. And the prosecutor struck him and said the reason was he wanted to get back to teaching. You know how anxious all students are to get back to school, and that's why he struck him. The white juror was Juror Laws, who was a contractor who had 2 houses that were coming to completion within the next week. His wife had just had surgery. He was having to take his children all over the town there to Jefferson Parish to get them to school. And as Justice Alito pointed out in his opinion for the Supreme Court, yes, Justice Alito of all people, he had a more compelling reason not to want to come back and serve on the jury, and he did serve on the jury. He was accepted by the prosecution and he served. But that argument had never been made at the trial court. It hadn't been made to the Louisiana Supreme Court. It was only made in the brief to the United States Supreme Court. Justice Alito dropped a footnote, and said, this might be different if there had been a question raised or an argument raised that this hadn't been properly preserved. But we noticed that the Louisiana Supreme Court, on direct appeal, did comparisons, not involving juror laws, but other jurors. And, well, it seems like the way in which this case was analyzed, that everything was up for grabs. But the Fifth Circuit and the 11th Circuit have both denied Batson challenges, saying that the side-by-side comparisons that were argued in the 11th Circuit briefs were not argued at the trial court level. And that's a very challenging aspect of this, in my opinion, is to do it at trial. Very easy to make these comparisons when you're doing them on appeal and you have the entire record, you have the jury selection, you have the questionnaires, all the information that's there. But if you're in a long, drawn-out jury selection, it can be a little more challenging, but that's a challenge we've got to meet. The other thing I would urge people to do is argue that we have to have a new standard. Argue that the prosecution should be allowed to have any strikes because of the way it has abused its strikes. Argue that there shouldn't be peremptory strikes at all. Don't worry. Don't get caught up on worrying about whether we have peremptory strikes or not. There's zero chance that's ever going to happen. But we do have justices on the Supreme Court saying that that's one remedy for the discrimination that goes on in jury selection. But most importantly, urge your court to adopt the rule that the Washington Supreme Court adopted last year, which is not whether there's intentional race discrimination under Batson, not whether the prosecutor lied about it, which no judge is going to find or not going to find very often in human experience, but this standard, whether upon the strike an objective person, knowing all the circumstances, would think that race was a factor in exercising the strikes. It's a completely different way of looking at this. The Washington Supreme Court had warned that it was seeing so many Batson violations that, as it said, race discrimination was rampant in jury selections in the state of Washington. And it said back in 2013, if this doesn't stop, we're going to do something about it. Frankly, I don't think many people thought they would. A lot of courts say that and don't do anything. But sure enough, they adopted a rule to look at this in a different way. They also adopted a bright line rule with regard to prima facie case, that if there's any person of color struck, then you go into the analysis and you apply this standard to it. You don't have to make out the prima facie case that Batson required. I want to go back just for a quick minute into history here, and the way in which Batson was greeted by prosecutors' offices, a couple of cases that came down right after Batson had been decided. No sooner had Batson been decided than Mark Bookman's good friend Jack McMahon, who was a senior prosecutor in Philadelphia, conducted a training program. Some of you may know about this, for young prosecutors there. This is after the Supreme Court had just said, don't discriminate on the basis of race. It violates the Equal Protection Clause of the Constitution. And Jack McMahon says, now when you've got a black juror, you're going to question them at length. And on this little piece of paper you have, you're going to write something down so that later on, when it comes time to tell the reasons for it, you'll be able to say, well, this woman had a kid about the same age, or this person lived in that part of town. And so you're going to ask more questions of those people in order to get ammunition to use your peremptory strikes against African Americans. Of course, this was never supposed to see the light of day. The only reason it did is McMahon ran against the incumbent district attorney, his boss, Lynn Abraham, and she suddenly, in an ethical fit, decided that this had to be released. He was 10 years old, I think, at the time. And so she released it, helped her get reelected, and also helped a number of people get Batson relief in their cases, because this is the kind of evidence, and the point I want to keep making is you're not just limited to the strikes in the case. Any information that tends to show an inclination to discriminate on the basis of race is relevant information. It has to be taken into account both with regard to step one, with regard to the prima facie case, and also step 3, when the determination is made whether there's been race discrimination or not. And then the other case to just mention quickly is Tim Foster's case, Foster versus Chapman. This was a case, too, that was tried the year after Batson. And the 2 court-appointed lawyers, the public defender and another lawyer who were representing Tim Foster, when Batson came down, did what good lawyers do. They filed a motion, and they said the prosecutor in this district has always struck all African Americans during jury selection. And they're going to do it in this case. And our client is an African American client, and we think the court should prohibit the prosecution from discriminating in selecting the jury in our case. And so the court has a hearing on it. A very interesting hearing, because at no point in the hearing did anybody suggest, the prosecutor or the judge, that there wouldn't be a Batson hearing. I mean, nobody said, well, maybe jurors will be struck in a racially neutral way and there won't be a Batson issue. No, everybody knew there was going to be a Batson issue once the juror was struck. And sure enough, they struck all 5 African Americans in the veneer, and the prosecution gave 8 to 12 reasons. They tried to pile on as many reasons as they could in hope that some of them would be held valid. They were upheld on direct appeal. We then do, and I think what good lawyers do, and this is totally serendipitous that this case came out the way it did, which is try to get your hands on every piece of paper that tells you anything about the case. And so under Georgia law, you've got an Open Records Act or Freedom of Information law that says that once a case is final and direct appeal, you can discover the prosecution's file. So we, of course, discovered the prosecution's file, and the prosecutor who had been in office had left, and a couple of others had taken place, had been in there in the meantime, and the prosecutor didn't sanitize the file or didn't shred or destroy the notes about jury selection. And so we get kind of like the McMahon tape. We get to sort of pull back the curtain and sort of see what was going on. And we saw the list. This went on for pages, this list of all the prospective jurors, and all the African Americans are highlighted in green, and there's a little B beside their name for those who are colorblind. And this was the list that went around for everybody to find reasons for striking the black jurors. And you might say, well, maybe they just wanted to separate black from white, and maybe it wasn't quite as bad as it looked. Whoops, I got too far ahead there. But then this is the way the jurors are listed in the prosecutor's notes: B1, B2, and B3 for the African American jurors. And then this memorandum that had been filed, and the prosecutor's was in the file, in which they analyzed all the black jurors, comparing them to each other, and saying, well, if it comes down, oh, this works on its own, doesn't it? Oh, I didn't know that. If it comes down to having to pick a black, maybe Miss Garrett would be okay. So obvious some race consciousness there that the prosecutor showed. And there were a number of other reasons, including the fact that the prosecutor just plain lied with regard to some of the reasons they gave. And then finally, the closing argument to impose the death penalty against Tim Foster in order to deter other people out there in the projects where Tim and his family live, 90% African American. Well, that resulted in a decision, of course, that only Justice Thomas dissenting of race discrimination. But as I said earlier, it's not going to help a whole lot in most cases, because you're not going to have this kind of information. It does show you the value of trying to get all this kind of information. We've since come up with very similar information in another case where the notes by the prosecutor pretty much revealed the discrimination that was going on. We've also, in other cases, found that, lo and behold, there are simply no records at all of the prosecutor's strikes. I don't know where they went, but they're now making sure we don't get those on these requests, but you never know. You look, sometimes you find it. The other thing that's interesting about this case is if it had gone to the 11th Circuit, it would have upheld this and Tim Foster would have been executed. This was a complete, as I said, serendipity to find the information, and then we litigated this in the state post-conviction court with a single trial judge denied our claim. Georgia Supreme Court refused to look at it, we petition the United States Supreme Court for certiorari. I mean, what's the chance the Supreme Court is going to grant certiorari? Zero. And lo and behold, the court granted cert, took it off this habeas, and so we weren't into any of the problems that you have with the review under federal habeas corpus, and the Supreme Court ruled in our favor on the case. But it's all a matter of sort of just things falling into your lap sometimes. But we can use these cases in some way. The Batson process is seen, and I was going to say earlier, it is a charade. It is a lottery. But I urge you, when I was saying raise it, buy a ticket, because every now and then, like Tim Foster's case, every now and then somebody wins the lottery. And a court finds that there's been a Batson violation. And every now and then the prosecution does something that reveals the race considerations that went into play. There's a court in the Illinois appellate court said that surely new prosecutors are given a manual when they come into the office with handy-dandy race-neutral reasons that they can give. And then it went through all the reasons that had been upheld, and they were a woman, they were a man, they were old, they were young, I mean, all these reasons. But actually, they're being sort of sarcastic when they said this, but in fact, prosecutors are given such a list. We know that in Texas, the Texas district attorneys and county attorneys had a seminar, Batson Basics. We know that the North Carolina prosecutors had a program called Top Gun 2, in which they distributed a form called Batson Justifications, articulating juror negatives. You won't be surprised to see any of these reasons. This is just, you take your race-neutral reasons to court with you, and instead of giving the actual reason, which of course is what you're supposed to do, you just simply look down at the page and you say, well, too young, too old, no eye contact, had eye contact with their defense lawyers, looked at the floor, looked at the ceiling. One of my favorites, boredom. We know how exciting jury selection is. Some of the jurors are bored, so that's a reason for striking them. Chew gum, more t-shirts, all of these totally trivial reasons, which all of these have been upheld, and so people just reading them off. Of course, once you discover these lists, then it makes it a little bit different. In North Carolina, the court's cases cited in the readings, court there found in 4 death penalty cases that the prosecutor had given the reasons off this list. Notice that the way in which the reasons were given, you could tell from reading the transcript that she had just read these reasons. She read the little prelude and then the reasons. He found that in all 4 of those death penalty cases, there have been strikes motivated by race in those cases. So if you have an ability through some kind of Open Records Act to get training materials, if you have former prosecutors or now defense lawyers who are now can tell you whether those kinds of lists are used. I think it's like so many things. If you can find them, they can be very helpful. In making your case. But a fundamental problem that we have, as Judge Mark Bennett said, the fundamental challenge of a Batson claim is that you have to make the prosecutor out to be a liar and a racist, that the prosecutor intentionally discriminated on the basis of race and then lied about it by giving a pretextual reason instead of giving the real reason, which is race. I think it's one of the things that really undermines confidence in the courts. You go and watch this Batson process take place. Of course, a lot of judges don't want to do it in public. They want to do it in chambers and want to do it at the bench. But anybody who sits there and watches and you see the reasons being given and the judge okaying them, everybody knows the real reason's race, and yet everybody goes through this sort of charade. But as I said, buy a ticket, because if you raise the issue, if you preserve it well, if you take it to your state Supreme Court, if you take it into state post-conviction or federal habeas corpus, you may be just the person who wins the jackpot. Let's talk just a little bit about what the standard is, and so forth. Batson, of course, changed the standard when it came down in 1986. Before then, the standard had been the old case of Swain versus Alabama. Robert Swain who was sentenced to death in Talladega, Alabama. And at the time of his trial, in a community that was 1/4 African American, there had never been a person of color ever on a jury in Talladega County. He challenged that, and the Supreme Court turned him down and said only if you could prove that in case after case, no matter who the defendant, no matter who the victim, no matter what the issue, that in every case the prosecution used peremptory strikes with the goal of keeping African Americans from participating. That was the only way you could prove a claim. Pretty difficult, actually impossible in most cases, and certainly impossible for people without much means to try to prove that. Batson changes that, says now the prima facie case can be based on the strikes in the case, as we all know. But Flowers makes this crystal clear. It's not just limited to that. So if there is other reason that shows the racial attitudes of the prosecutor in the case, those are going to be relevant as well. And I'll come back to some of that. Prosecutor at step 2, the court does this 3-step analysis, which it comes back to in every single Batson case. Doesn't seem to need to make it any more complicated than it is. But second step, the prosecution has to give reasons. It's not a burden of proof, it's only a burden of production. And I'll come to Perquette in a moment. And then at the third stage, after looking at the prima facie case, after hearing the reasons and look at any other evidence, the judge decides based on the totality of the circumstances, all the facts, not just the reasons given, whether there is substantial motivation or substantial evidence that it was motivated by race. And the burden of proof at the third stage is on us. It's on the defense. Some thought when Batson came down that it might be a burden shifting. The prosecution gave reasons, and unless the prosecution could explain away the prima facie case, there'd be a violation found. But the court clearly didn't hold that way and certainly hadn't held that way in the other cases. The court has started cutting back on it almost immediately in Hernandez versus New York, which came down in 1991. And the court said if the reasons correlate with race, they're still race neutral. In that case, the prosecutor's reasons for striking all the Hispanics was that they could speak Spanish. It doesn't seem like a very good reason, but they said we want everybody to base what they hear on the translators and not based on their own knowledge of Spanish. Remarkably, the Supreme Court upheld that, also made it clear that the standard is clearly erroneous when cases are on appeal. Difficult, but not impossible standard. The Perquette case, a little per curiam case that just came down the Supreme Court, no briefing, no argument, just decided on the papers. And the court said the reasons could be silly, they could be superstitious, they could be any kind of reason in the world. At step 2, you don't assess the validity of the reasons. That's only at step 3. This is not a helpful case, obviously. After Batson, the sense was that the reasons had to be case-related in some way. Perquette makes it clear the reasons do not have to be case-related. The Georgia Supreme Court not too long ago had forgotten to sort of change its analysis and said, we've been requiring the reasons to be case-related, and instead of saying, we're all trying to enforce Batson, they said we're going to hold that they don't have to be case-related. And then all these very unique cases that the court decided. The 2 Millerell cases out of Texas. Thomas Millerell first came up one time whether there was a certificate of appealability to have the case reviewed at all. Fifth Circuit said no. The Supreme Court said yes, sent the case back down. Fifth Circuit denied. Supreme Court grants relief, showing that even in the very deferential standards of federal habeas corpus, you can prevail in one of these cases, but again, a very extraordinary case. Millerell's lawyers had actually started out to prove a Swain claim before Batson had been decided. And they put in a lot of evidence about the Dallas District Attorney's Office. They had a manual that said right there in the manual, black and white, strike blacks, Jews, others, but they had former district attorneys come in and say, we were trained to strike all the blacks. They struck 10 out of 11 in the particular case, gave reasons which didn't wash with some of the reasons or some of the white jurors that they accepted. but a very detailed, very case-specific decision decided by the court. In Johnson versus California, the court took a case where the California Supreme Court had said no prima facie case. There was 3 strikes and all 3 against African Americans. The Supreme Court reversed, said there was. So that case is somewhat helpful. Snyder is another case that actually had some of the same unique features that these other cases had, but fortunately, the court didn't put them in the opinion. So I think of all the Batson cases that are out there, the one that comes the closest to being a sort of garden variety case. This is a case out of Jefferson Parish, Louisiana. The prosecutor, as he always did there, struck all the people of color. I'll just go ahead and mention this point. One of the problems with the case is they did it in panels. The very first panel had Jeffrey Brooks, the young African-American who was ultimately struck, but the prosecution accepted him. And then second and third panels, there were no blacks. Fourth panel struck one African-American. Fifth panel struck one. At this point, the defense says Batson violation, which just shows don't wait because then the prosecution in Louisiana allows you to backstrike. So then they struck Brooks and they struck the rest of the blacks. But when the case was up on appeal, the state's argument was they only objected to 3 of the jurors. They didn't object to the first 2. Fortunately, the lawyers had used the word pattern at some point in the objection and said there was a pattern of strikes, but that case could have very well been lost just on that. So we want to be sure to object to every single person of color that's struck by the prosecution. But it is a case, a direct appeal case, a clearly erroneous standard case in which the Supreme Court reversed the Louisiana Supreme Court and found that there was a Batson violation. And then the other 2 that I've already talked about, Foster and Flowers, were the other 2 cases that we've had pretty recently come down from the Supreme Court. So let's just go through the practice and what we do, some of the legal issues that come up, and some of the tactical questions that we want to think about. Step 1, the defendant challenges, again, assuming that it's the prosecution striking and the defense challenging, the defendant objects. And as I just said, with regard to Snyder, the lesson out of that is object to every single juror. You may think, well, perfectly clear he'd strike that juror. That juror was adamantly opposed to the death penalty, but somehow the judge didn't strike them when they were challenged under Witherspoon versus Illinois or Wainwright versus Witt. And now the prosecution's striking him. We'll worry about that on appeal. But for now, object to every strike of an African American. Also, so the prosecutor knows that those strikes are going to come and they're going to have to give reasons for them as they come. There's some dispute in the states now about what makes a prima facie case. I think Batson itself pretty much makes it clear that if it's a disproportionate number of strikes, if there's 6 African Americans and you excise 10 strikes and you strike all 6, that's a prima facie case, 100%. If there are 3 and you strike 3, that's Johnson versus California. That's a prima facie case. But the Louisiana Supreme Court, in a number of cases where there's been about a few blacks left on, it said this is not a prima facie case. And they've even said in a couple of cases, this is not a numbers game. I don't know what it is except a numbers game. That's what Batson said. You look at the number of strikes and whether it's disproportionate or not. And if it is, then the prosecution has to give reasons. What some aggressive prosecutors are trying to do in Louisiana and Alabama, at least that I see, they don't want to give reasons. So they're arguing to the trial judge, they haven't made out a prima facie case, so I don't have to give any reason. And the reason for that is that where prosecutors do give reasons, generally the court is going to look at the strikes and the reasons later on, and it's not going to get into the question of whether it was a prima facie case. That's just something to be looking for. But any other evidence that you have, and this is why keeping the records in all the cases, if you have a prosecutor's office that's striking at 90% of the African Americans and 11% of the white people, or if every opportunity, you look at opportunities to strike. There are not going to be that many African Americans in many jury veneers. So there are only 5. So he strikes all 5. And the next trial strikes all 3. The next trial strikes all 4, whatever it is. In each one of those cases, that's not terribly compelling, although it's pretty obvious what's going on. But you keep adding those up, case after case after case, and that's what they did in North Carolina. They looked at the peremptory strikes that the prosecution had exercised in every single capital case. And the study, the Grasso article and study about that is cited in the materials, but the numbers were just undeniable when you have that grade of numbers, and Judge Weeks found that there was racially motivated strikes going on. Step 2, of course, as we talked about, the prosecution gives the reasons for the strikes. I advised contest the reasons if you can. In Snyder, one thing that happened was the prosecutor said he struck Brooks because he was nervous. And the defense lawyer immediately said, nervous? Hell, we're all nervous. Everybody's nervous. These people are here in a capital case. Is that where the guy's going to live or die? They're nervous. I think that pretty well wiped that reason out. And those kinds of reasons that are given, and of course the demeanor reasons that are so often given. Sometimes you can make your own representation with regard to it. You know, I was watching that juror. I never saw her roll her eyes. I never saw her look down at the floor. She didn't make eye contact with my client. Whatever it is that they're talking about. And if all else fails, you won't get it. But ask for a hearing, because you're going to lose right now. You're not going to be in any worse condition after the hearing. But if you do have a judge, brings the jurors back and has a hearing, and the Washington rule requires that with regard to any demeanor reason, the court has to have a hearing. Object to piling on reasons, as I said, what the prosecutor did in Foster was 8 to 12 reasons for every juror on the theory that surely some of them are going to work. There's a case out of Florida, a death penalty case, cited in the materials, in which at trial the prosecution struck a young African-American woman. Defense objects. Prosecutor, she is a young black woman and the defendant is a young black man. That's my reason for striking her. That prosecutor obviously didn't get the memo, because that's not going to cut it. But then he said, and in addition to that, her answers on the death qualification question were weak. So those are the 2 reasons I struck her. Florida Supreme Court said, well, the first reason obviously is race. You can't do that. But the second reason's okay, because he had a race-neutral reason. Case goes on habeas corpus. Same case goes to the 11th Circuit, and the 11th Circuit holds the same thing. Upholds the Florida Supreme Court and says even though one reason was clearly race and the other reason wasn't, I think those cases are wrong. I think these cases that we just went through are very helpful when they talk about substantially motivated. They're not saying it's the only reason. They're just saying that part of the reason. Obviously, you strike jurors for a whole lot of different reasons. There's not one reason, and you can't isolate one reason. But that's something to look out for. There's also courts that have said that if there's any race at all, that taints the strike, and you can't do the strike if there's any use of strike at all. There's also a couple of decisions, fairly obscure decisions, but we found them to cite in Foster, that say piling on reasons is evidence of race discrimination itself. That if the prosecutor just keeps giving reason after reason after reason to see, let's just throw enough spaghetti at the wall and see if any of it sticks, that if that's what's happening, that's an indication of race as well. One thing critically important about the third part, consider all the evidence, as we talked about. Was the strike motivated in substantial part by discriminatory intent? That's not just straight up, was it absolute race and nothing else? Very important to make sure the record is clear on this. I see Batson cases that are lost because there's no record. Actually, in the Flowers case, 1 of the 6 trials, there's no record of the jury strikes. Unbelievable. This case gets reversed on the 3rd trial because of 15 for 15. Only the 6th case gets reversed because nobody knew that at the time of the 5th trial. And yet, the 5th trial, no record of the strikes, of the race of the jurors, of who the prosecution struck and who the defense struck. You got to make absolutely sure that that's part of the record, and that's not an infrequent problem, that the record is not clear. So make sure that is. Make sure that all the jury questionnaires and every part of the record is a part of the record. The jury questionnaires, of course, have all kinds of information which are helpful. At point 3, at the trial level, as I said earlier, side-by-side comparisons. How do you compare? You got to show the equal protection violation, that is, a similarly situated white person was accepted and an African American with those same characteristics was struck. Now, the Fifth Circuit, in a case called Chamberlain, en banc, had taken the position that it wasn't going to consider side-by-side comparisons because it said the prosecutor only gives reasons for striking the juror. They don't tell you anything about the reasons they accepted the white juror. And there might very well be other reasons that we don't know that were the reasons the prosecution accepted the white jurors. So they reversed a panel decision. There's a biting dissent in that case in which the judge points out that the Fifth Circuit has only found one Batson violation every decade since Batson was decided. But Flowers makes it clear that that's wrong because Flowers does side-by-side comparisons. Judge Kavanaugh wrote the opinion in Flowers. He had written a law review article on Batson when he was a law student. And you could see this like, I'm a new Supreme Court justice, and this issue I know something about, and I'm just going to write this great opinion and talk about all these things. And so instead of just doing what probably one of the more other conservative judges would have done, which is just hone in on the facts and reverse the case and get out of there, he talks a lot about Batson and how it's supposed to apply and how important it is, and particularly when you have so few people of color in the veneer, how important it is that the courts be on guard that those people are not struck on the basis of race. But he also does, they have to stretch, in my opinion, in Flowers to make the side-by-side comparison. This is in a teeny little place, Wyona, Montgomery County, Mississippi. Some of you may know it's down from Memphis and up from Jackson, Mississippi. And it's this little community where everybody knows everybody. And certainly all the black people, 45% African-American, 55% white. And the whole case is about race. Curtis Flowers, African-American man charged with killing 4 people at a furniture store. And so the 2 cases where there are actually more than a few blacks on the jury, those hang on basically on race. White jurors guilty, black jurors not. And so the prosecution's trying to get rid of the blacks and accepting the whites. The comparison that's done was somebody who worked with Curtis Flowers' father and knew him pretty well, and said, well, he knew all these people, so we struck him. And they compared that with a woman who's a teller at the bank, which is a little bit different because, of course, if you're a teller at the bank, you meet everybody in town when they come to do their banking and all that. But that's what the court found to be the comparison that resulted in Flowers prevailing. It seemed to me that case that the race discrimination was so strong in it you could almost say it just based on all the other evidence without the side-by-side comparisons. But I would say if in doubt, in arguing to the trial court, try to make as many comparisons as you possibly can. You can always do something different on appeal. The appellate lawyer or you as appellate lawyer, you look at the transcript, you study it, you read everything in voir dire, you look at the juror questionnaires, you're obviously going to be able to improve on that, but you want to make as strong a claim at the trial court level as you possibly can. Other factors, whether the prosecution engaged in meaningful voir dire examination of the jurors. There are 2 tricky things here that can happen. One, prosecutor doesn't voir dire the jurors. This happened in Foster. One of the reasons they gave for striking one of the jurors, the court said, well, they must not have been very worried about it. They never questioned him about it. And if they had questioned him about it, they might have found out something different than what they thought about it. On the other hand, in Flowers, what the prosecutor did, which not very bright in my opinion, he questioned the black jurors a whole lot, trying to find reasons to strike them, but hardly question the white jurors at all. And in both those cases, those practices were found to be indicia of racial bias. Not questioning the African-American juror in Foster, and disparate questioning the blacks a whole lot more in Flowers than the white jurors were questioned. Whether the record supports the reasons given, because sometimes the prosecutor gives reasons they really don't have any support for it on the record. Also, whether the prosecution mischaracterizes. In Flowers, that was found with regard to some of the reasons given, that what the prosecutor said was not really accurate with regard to why the jurors were struck. Where there's manipulation of the process. In Texas, as those of you from Texas know, there's this very unusual practice called the jury shuffle, where the jurors come in and they're all sitting out here like this, and I look out there and I say, I don't like this. Let's shuffle the jury. And they shuffle the jury and they come back in ranged in another manner. The craziest thing I've ever seen. I can't imagine what the point of that is, but we know that in Miller-El, the prosecution, every time they were African Americans sitting towards the front, and they take the jurors in the order that they're aligned there, would call for a jury shuffle in hopes of getting the African Americans back to the back. In Snyder, not quite as unusual a practice, this backstrike that the prosecution accepted Jeffrey Brooks at the start, but then much later used a backstrike against him, which we at least tried to analogize to the shuffle that had been used in Miller-El in that case. And of course, I can't say enough, totality of the circumstances, all the possible circumstances you have. And if the judge does rule strike by strike or juror by juror as the reasons are given, be sure, this is, in Snyder this was done this way, it was juror by juror. There was never any motion at the end, which is when the defense should say, I want to renew my strike to each, my objection to each and every African American struck, and based on the pattern of discrimination, based on the comparisons with the white jurors, even if you don't specify what it is, based on all of those circumstances, I want the court to please reconsider each and every one of my Batson challenges. This judge's not going to do it, but it's going to make a good record for an appellate court, and you're going to have the argument both on appeal and also in habeas. I won one of these cases in habeas because we argued that the state trial judge, in ruling on the Batson claim, didn't consider the totality of the circumstances. He only considered it juror by juror, and therefore he didn't apply the right legal analysis. And when the Court of Appeals applied the right legal analysis, it found that, in fact, there was a Batson violation. And then, of course, raise each and every challenge on appeal, depending on where your case is going. If it's a death penalty case, this case is not going to stop at the Oklahoma Court of Criminal Appeals or the Alabama Court of Criminal Appeals or the state Supreme Court, wherever you are. It's going to be, you're going to seek cert in the Supreme Court. Never going to get it, except wait a minute, you do get it in Foster and in Snyder. Just garden variety cases, but that had a little something there that got the court to take it, so you just never know. But challenge every strike, try to make as many side-by-side comparisons as you possibly can. Well, let me just finally talk for a minute about this rule in the Washington Supreme Court. You may say, my state is never going to do this. But if you are in any place, like North Carolina now has some progressive people on the state Supreme Court who might start filing dissents or might start agitating for this. And there may be other states where if it's not now, it may be later, that might think of adoption, because I think everybody agrees that Batson is a failure. Everybody agrees that there's still discrimination. Everybody agrees that the judge doesn't know whether reasons are true or false. Everybody knows the judge probably struck people himself when he or she was the DA and now upholds the reasons. So something needs to give on this. As I said earlier, the standard is whether once there's an objection, the reasons are given, and you ask whether an objective observer would view race or ethnicity as a factor in the use of the strikes. Now that's pretty good, but this rule gets better. The court describes the objective observer as a person aware that implicit, institutional, and unconscious biases may influence what somebody does. It makes it clear intentional race discrimination is not required. And what the whole problem with this unconscious bias that Jennifer Eberhardt, that Mark Bookman talked about, has demonstrated so well, is that, well, it was unconscious race bias, it wasn't intentional race bias. The Washington Supreme Court has made clear it doesn't care where the bias comes from. And if there is bias that influences the jury selection, it's not going to be allowed. Get this, the following reasons are presumptively invalid: having a prior contact with law enforcement, expressing distrust of law enforcement, having a relationship with people who have been stopped, arrested, or prosecuted, living in a high crime neighborhood, having a child outside of marriage, receiving state benefits, not speaking English. Another reason presumptively invalid, juror was sleeping, inattentive, or wasn't paying attention. I don't know about you, but this sounds like my kind of jurors that we've been talking about here. And with regard to any of these demeanor reasons, if anybody raises those, then there has to be a hearing and the court has to make a determination. Again, you're probably not going to get your court to do this at first, but that's how the rules change by litigating. And the other thing is, though, this rule, particularly all these parts of it, is sort of like a little amicus brief. They say, look, this is not me, this is not the ACLU, this is not somebody like that. This is the Supreme Court of a State of the Union that's adopted this because it's seen the problem that almost everybody sees with regard to Batson. We got to try something. And the court is never going to do much about peremptory strikes. That may be just as well, but that doesn't mean that that's all or nothing. I read something where someone said, well, since the court's not going to do away with peremptory strikes and no jurisdiction is going to do away with peremptory strikes, there's really nothing we can do. And my message here is there is something we can do, and it's what the Washington Supreme Court adopted in its rule. Okay? I think our time's about up, isn't it, Mark? 5 minutes. Any questions? Yes? Do you have the sign for that Washington gate? It's attached to in the materials. The rule is set out, and all what I just read is set out in the materials. Yes? I don't know anybody that's done it, but I think that's a very good idea. In Kentucky, they don't have court reporters. Everything is televised. Everything is videotaped, I mean. And so you have that record in every case, and there are arguments being made based on what you see in the videotape. Yeah. But that's a good idea, particularly if you've got a prosecutor who's using those reasons all the time. Anyone else? Yes, ma'am. Yes, sir.
Repeat the question.
Oh, yeah, okay. The question was, does it make sense if this is happening, if a lot of, or whether it's happening or not, if you want to deal with demeanor reasons, videotape the jury selection. So, of course, you got to make sure the videotape is of the juror and not of the lawyers. Yes. Yeah, Batson applies to everybody. It applies in civil cases, it applies in criminal cases, it applies to defense, it applies to prosecution. It applies whether your defendant is white or whether your defendant is a person of color. All of those, the Supreme Court has made clear, Batson applies. What I find disturbing is in cases where prosecutors, Batson, me, or defense lawyers saying we're striking at white people. White people are never held in slavery as far as I know. They're a majority of the population. The majority of the population in the place where you're picking the jury. It's a completely different dynamic than where you have a minority of 4, 5, 6, 8, 10 people that are being struck because the prosecution has more strikes than there are people of color in the veneer. But nonetheless, that's been rejected. We had a case, a state senator named Walker, who was tried in federal court in Georgia, and both sides, Batson the other, and the judge, who was an old-timey racist, hateful judge, rejected all of the defense strikes of the prosecuting striking blacks, but upheld 3 challenges the prosecutor objecting to the defense striking whites. It's outrageous. And it was upheld on Walker versus United States. It was upheld on appeal. Anybody else? One last question before we go? If not, thank you very much.